A viewer writes, "My patent has expired. Is it too late for me to sue for patent infringement?" And the answer is, maybe it's not too late. I'm going to explain this and discuss other patent enforcement issues on this video. Hi, my name is Carr Ferrell. I'm a Silicon Valley patent attorney. Welcome back to my channel. Okay, here's the viewer's fact pattern. He filed his patent application in the year 2000. The patent issued 2 years later, and the patent then expired 20 years after the filing of the patent application in 2020. Now, there was no additional time added to the term of the patent through a patent term extension. So the final date was 2020. That was the final year of the patent term. So the question is, now in 2025, is it possible to sue the infringer for patent infringement, even though the patent has now expired? And the answer to that question is yes. Under Patent Statute 35 U.S.C. 286, the patent law allows you to collect damages up to 6 years from the date of the filing of the lawsuit. We're filming this video in 2025, so if we were to file a lawsuit right now, we could look back 6 years for the collection of patent damages. And so that would go back to the year 2019. So although the infringement during the period of 2020 to 2025 does not include any eligible patent term because the patent had expired, we can still look at the period in 2019 as a period of possible infringement during which damages may have occurred and damages would be collectible. The point here is that even though the patent may have already expired, assuming certain notice requirements have been met, it may be possible to look back as far as 6 years from the date of the filing of the lawsuit in order to collect damages for patent infringement. Okay, next question. A viewer writes, "John, I found someone infringing my provisional patent application on Amazon. How can I stop them from copying my product?" Well, the answer to this is, since you only have a provisional patent application, there's actually no patent, there's no issued patent that's being infringed. The provisional patent application is merely a placeholder application for holding the priority date for a later filed utility application. To stop someone from infringing your patent, you must have a patent that's being infringed. A mere provisional patent application is not sufficient to stop patent infringement. Okay, here's a related question to the last question about suing on a provisional patent application. The viewer writes, "John, I filed a utility patent application 6 months ago, and I just noticed now that my patent application is being infringed. It seems to me I remember a video that you did a while back that says that I can sue on a utility application so long as I give notice to the infringer that they are infringing my application. John, could you refresh my memory on how this works?" First of all, thanks for watching my video. That one was a while back. If someone is infringing your utility patent application, and if you send them or give them actual notice that they are infringing your patent application, then it's possible once your patent issues, and assuming that at least one of the patent claims in your issued patent that is infringed remains unchanged from the original published application, then it may be possible to go back and collect damages from the date of the actual notice given to the infringer. So to make all this work, a couple of things have to happen. First of all, you need to file a utility patent application. Secondly, the utility patent application must publish. Next, there must be at least one claim that's materially unchanged from the time that the application is published to the time that the patent is granted. After the patent application is published, you must give actual notice to the infringer that you believe the patent claim is being infringed. Once the patent issues, then you must file a lawsuit claiming damages back to the point at which you gave actual notice of infringement of that patent claim. Okay, let's say that your patent application publishes, but the infringer isn't exactly using the claim that's been published in your application. What can you do? Well, one thing you can do is to file a continuation application and rewrite the claims so that they better cover the infringed product that you're trying to stop. Since the continuation application is published in the file wrapper, it's available online in the patent office, then once you provide actual notice to the infringer, it may be possible once that patent issues to use that patent claim to go back and get past damages. Okay, this seems a little complicated. It's really not so much, but something to keep in mind that you'll want to discuss with your patent attorney about in the event that you're contemplating litigation against an infringer. The next question, the viewer writes me, John, I would like to manufacture a product and there's a related product in the marketplace and that product has a marking on it that says patent pending. I've tried to search for the patent and haven't been able to find any related patents. And I even wrote the manufacturer and asked them if their patent is pending and if they could send me a copy of any issued patent they had. And I haven't heard back. What do I do? I'd really like to manufacture this product. And this competing product, this related product, has been on the market for several years. And as far as I can tell, there's just no patent. Okay, there is no real easy answer to this one. I can think of 4 reasons why someone would have the words patent pending on their product for multiple years. The first reason is it's just false marking. They've put the words patent pending on their product in order to chill the marketplace. But it's important to understand that this is a violation of federal law, of 35 U.S.C. 292. And if you end up getting into a lawsuit with them and it turns out that they have falsely marked their products patent pending, that's an act of unfair competition and you may be entitled to lost damages as a result of this false marking. The second reason their product may be marked patent pending is they originally filed a patent application, but for whatever reason they abandoned the application. They decided not to pursue it, possibly because someone else had already invented the product or the invention that they were trying to get a patent on. The third reason their product may be marked patent pending and you haven't been able to find a patent is that their patent is pending, but it remains unpublished. They've chosen not to publish their patent application and their application is still pending. It's possible to withhold publication of your application by petitioning the patent office, not to publish your application and giving up the right to pursue foreign patents on your product. And finally, the fourth reason I can think of that patent pending would be on a product for so long is that initially the product was patent pending, and in the interim since then, the patent has issued. You just haven't found it yet. So the next question is, what do you do from a business standpoint? How do you approach this problem? The first thing that I would recommend that you do is to commission a professional patent search. Now, I understand that you've searched this yourself, that you've done your own patent search and haven't been able to find an issued patent covering the technology. However, if you are contemplating manufacturing the product, going into business, selling the product, then I think it's worthwhile at this point to hire a professional patent searcher to help you with this inquiry. It's much better to spend a little bit of money now getting a professional patent search performed rather than face a litigation at some future point because you're infringing someone's patent. There are lots of professional patent search companies that advertise on the internet, and finding a competent professional service shouldn't be that hard. In addition to looking for that particular patent, I think it would also be useful to check for prior art and see if there's prior art, that is, previous patents that might invalidate the patent pending that's marked on that particular product? Has someone else already invented that product before? Perhaps a previous patent that's now expired. So in addition to searching for that particular patent, that active patent, also consider doing a separate patent search to try and invalidate any patent that might currently exist on the product. One of the reasons for doing this is it might give you some insight as to whether and why this particular patent might have been abandoned if there's no existing patent on the invention. And then finally, it's useful to sit down with your patent attorney and do a risk analysis. Given the information from the 2 patent searches that you've done, what is the risk you face if you decide to go forward and manufacture this product? What patent defenses could you raise in the event that you were sued for patent infringement? And what damages would you likely face? Every business is a risk, and the reason that you earn a profit as a business is because you take a risk. And the goal here is to mitigate and to minimize the risk as much as you possibly can. And a skilled patent attorney should be able to help you do that. Okay, that's all the questions I have for today. Thank you so much for submitting your questions and your comments, for watching my video. If you have additional questions, put them in the comments section below. I'd love to read them. If you need help with your patent or your company's patent portfolio, I'd love to hear from you as well. Please reach out at the email address below. Thanks again for watching my video. I'll see you on the next one.